The latest chapter in the Karen Reed saga. As her January retrial date quickly approaches, Reed and her attorneys were back in court today for a series of motions, including a request to postpone her retrial until April. Now, earlier this month, the Massachusetts Supreme Court heard arguments from her attorneys asking for the top charges to be dismissed in the death of her Boston police officer boyfriend on the basis of double jeopardy. Now, Reed is accused of backing her SUV into John O'Keefe and then leaving him to die on a snowy road in 2022. She claims that she was framed in a widespread cover-up by law enforcement. Well, at today's hearing, both the state and the defense argued a number of motions, including a Commonwealth motion for Verizon cell phone records and a defense motion to unseal sidebar conferences from the first trial for the lawyers only to use so that the Commonwealth's new prosecutor could get up to speed. Also at issue was prosecutors notifying the court they intend to reassemble and retest the black box and infotainment system in Karen Reed's Lexus. So let's go in now and listen to some of those arguments.
The Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that why the information was not available. Also, in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case. And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission, rather it was to notice them this is what we were going to do. You can see from my motion I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they are entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them. And so I've spoken to the defense. I know they've hired an expert. I know they've filed a motion contesting our position. I'm not going to speak for what their position is today, but I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they'd want, but we're entitled to the download. Notably, when the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility. But it was the defense expert that overlooked the proper reader that was needed for the chips that were tested, and it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights, and that's why we now have an independent expert that is going to do this. I know experts differ. They're not frick-a-frack. They all have different opinions, but we've attached all of the protocol, what we intend on doing, and the reason I brought it before the court is I wanted to expedite this matter. It's important, and it does.
I thought we were going to have that hearing within 14 days when we first got the motion, and then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then, but as of right now, it's still January 27th. So all of these things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, 'cause it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
how long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to. But they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I'll start by saying, in principle, we don't have an objection to the retesting of the telematics or the infotainment center, our system data. The problem that we have, our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip-off, physically did not know how to do it. It was Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former MSP officer and extremely facile in this world.
And you have a different expert now. You're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip-offs and chip-ons, that physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure. He knows how to do it. He's got an extremely long resume, having done this kind of work.
I read it.
We're bringing him up to speed in order to sort of engage in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2-micron chips and the spansion chip that he looked at, didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Burla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips that didn't exist when Ms. Gaffney did her work previously. She put it on a reader, it was unreadable.
Alan Jackson, such a great attorney. He's already disparaging the state's expert. It's amazing. Great stuff. All right, we're going to hit the pause button right here. We're going to take a quick break, but when we come back, the prosecutor pushes back on the defense's request to work with the Commonwealth's expert and oversee the handling of the vehicle computer chips. So keep it here on Court TV, your front row seat to justice.
Tonight on Closing Arguments, a mother faces a jury for allegedly killing her own daughter. We'll break down today's biggest moments in the cult baby murder trial.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
This case, brutal murder of Laken Riley.
We have a suspect. He did not know her at all.
Such a violent act. Will there be justice for Laken Riley?
The murder of Laken Riley. Live coverage begins Friday, only on Court TV.
I'm out here telling people how they...
Welcome back, folks. Before we head back to court, let's bring in our guests for this hour. Joining us, trial attorney, former public defender Gabrielle Higgins, also criminal defense attorney, former prosecutor Joe Tamburino. Great to see you both. Thank you so much for joining me tonight on the program. Gabrielle, I'll begin with you. I thought in the first trial, one of the weakest areas for the state was this accident reconstruction part. They just brought in a police officer who kind of put some stuff together. They're claiming that the information they really needed was kind of messed up by the defense's expert. Sounds like they plan to bolster that part of their case. What do you make of what we heard so far?
I think that digital systems, specifically an infotainment system, are typically very volatile. And so you heard a lot of this in the hearing, that if you have a limited understanding, like they claim the state's expert had a limited understanding of infotainment systems, then not only is the analysis faulty, but there's a risk that the actual data was mishandled and as a result, likely not preserved. Typically, the absence of information lends itself more favorably to the defense. And so it's in the defense's best interest to say that, yeah, this data was not only analyzed, but it was mishandled and it was missing. And that's really the state's burden. That's not really our problem. The state's trying to shift that burden in a way that I don't think is going to be successful.
Joe, I got to ask you, it sounds like they want to have their expert there to kind of oversee what's going on because they don't trust or don't have confidence in the expert that's being used by the state. I thought it was brilliant by Alan Jackson. He knows these things are televised. He gets it out there that, we don't have confidence in their expert. But more importantly, could it be possible? Now, the way it was laid out, only about a third of the information that was on the black box and infotainment system was available in the last trial. Now, if we get all of it, is it possible that we could get the answers we've been looking for? What actually happened? How fast the car was going? Did it back up? Did it make that U-turn? Et cetera, et cetera.
Yes, and Michael, what you point out is a really good thing that happened in the first trial, which is the prosecution's case not that it fell apart, but it had some challenges. And one of the challenges was the accident reconstruction. And so by doing a new reconstruction, you're quite right, we might get answers to this. And I have absolutely no problem with what the defense asked, which is to have their expert review this or look over the state's expert as they do the reconstruction, as they get the materials together. And that's quite common. I mean, many times you will have a defense expert go and view something that a state's expert is doing. So I think they're doing the right thing.
Gabrielle, I want to go back to you quickly because you mentioned that this type of information can be volatile. I want to check back and know what you mean by that with your experience with this type of information. When you say volatile, what do you mean?
I think there were mentions of the chip on and the chip off system. So when you're dealing with the chip on system, you're talking about the actual chip that's in the vehicle itself that contains the data. So when you're dealing with different power sources, when you're analyzing the data on those chips, some of that data could be lost in the process of trying to extract the information that you're looking for. That process requires an expert that's not only experienced in the complexity of chip on and chip off systems, but also an expert that's able to preserve that data for other experts to be able to review it. That's not an easy thing to do.
Fair enough. And Joe, in this retrial, it's becoming clearer that there's going to obviously be some different tactics being used, but both sides know what's coming now, right? And I think that's important in this case. And there are some real issues, as we saw, for the state in their case, including, Detective Proctor, just to name one. Who has an advantage in this retrial, in your estimation?
The defense always has the advantage in a retrial because here's why. anytime you start a trial, because of the discovery process, you pretty much know from the defense what's coming at you from the state. And then you do your trial number one, and the state sees what the defense is. But I still think when you get to trial number two, the defense knows all of the state's theories. They know all of the discovery. They've seen all of the evidence. They've seen how it's played into the jury. So I think they have the upper hand. Additionally, the defense and the prosecution is agreeing, it seems that they are agreeing, to release, at least partially to them, the information or the transcripts when they had at the bench conferences. I mean, I think that's just, the tip of the iceberg. I think that if the judge releases it to the attorneys, sooner or later it's going to be publicly released, and I'd love to read what those are.
Yeah, that's going to be a little bit of a problem. We're going to get into that a little bit later in the hour. Right now, I want to go back inside that Massachusetts courtroom. Here, Karen Reed's attorney is arguing the defense needs their expert to be present when the testing is done on that Lexis information system. They point out that the state's expert from the first trial used outdated software and that was only able to retrieve about a third, as I said, of the available information, possibly, at least according to the defense, excluding evidence that could have been helpful to them. Let's go back in.
It doesn't mean that the data is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm going to use some made-up numbers, but let's say there's 5,123 bits or bytes on a particular chip. You can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2-micron chips and the spansion chip, back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert be obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is, if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
All right. Any response, Mr. Brennan?
The defense expert would not be working with Mr. Burgess. He would be observing Mr. Burgess. The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto power during the process. That will delay things. It has no role and no purpose in it. And so, inevitably, Mr. Burgess is well qualified. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It will provide the information that will be available to both us and the defense.
All right, so if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence, and I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule. So I can't give an exact date because that conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right, this one I will act on very quickly. All right.
All right, what we're going to do now is squeeze in a quick break. Coming up on Court TV, both the defense and the Commonwealth want Karen Reed's second trial to be delayed. But the judge is not too keen on the idea of pushing the retrial from January to April. The line of questioning is straight ahead. Keep it here on your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. Now back to Massachusetts, where Karen Reed returned to court this morning for a motions hearing ahead of her murder retrial. 44-year-old Reed is accused of backing her SUV into her boyfriend, John O'Keefe, and then leaving him to die on a snowy road in 2022. She claims she was framed in a widespread cover-up by law enforcement. That first trial ended July 1st with a hung jury. And her team is trying to convince the state Supreme Court to drop some charges ahead of the second trial. Oral arguments were presented to the justices last week. Attorneys, along with the defendant, were in court today, arguing a joint motion for the trial to be pushed back to the spring. Well, now there is a new special prosecutor on the case, Hank Brennan. You saw him talking earlier, and that he's really given the state's reason now for asking for more time to present the case. Now, they both agree. They both want more time. Now, the judge still wasn't too excited about that possible delay. So let's go back into court for more of that hearing.
So I think that just leaves us with the motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
Should I begin?
Yes.
Okay.
And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter-experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these chips in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable, I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony, they're retaining experts to counter that testimony, and then to reciprocate in discovery where days, weeks, or in the midst of trial. I want to avoid unfairness to defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates numbers, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial, and it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial, and I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right. Who's going to argue this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the time frame, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts depending on what the testing
Have you been working on that, though, in anticipation?
We have,
okay.
Yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into a trial. And we're really trying to avoid that this time. It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests.
All right, we'll step aside here, take a break. Coming up on Court TV, the judge questions both the defense and the prosecution about what is needed to move the case forward. The defense wants to bring in a dog bite expert to speak to the marks on victim John O'Keefe's arms, just as they did in the first trial. Find out what the judge has to say about the Daubert hearing and the joint motion to delay the murder retrial. That's next, so keep it here on Court TV.
Tonight on Closing Arguments, a mother faces a jury for allegedly killing her own daughter. We'll break down today's biggest moments in the cult baby murder trial.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
Tyler, why do you think you killed your parents?
This is going to get out of my head. Interview with a Killer. Season finale, Sunday, 8/7 Central. And don't miss the new season coming in 2025, only on Court TV.
All right, we're wrapping up the hearing in the killer or cover-up murder retrial of Karen Reed. So let's hear the judge's response to that joint proposal to change the January trial date to April.
What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions that we have. So we need to start moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
We have not yet drafted the motion, but I've given it much thought. The government at trial called an expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine. All right.
That expert, I did not believe, followed the proper methodology or had the expertise to make.
All right. Does the defense intend to call Dr. I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
I expect that she will be on our witness list.
All right. So why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
Okay. So why don't we set a Daubert hearing? I know you'll have to fly her in, but why don't we get a date now in December for that?
Does the court anticipate that being a different day than the date we're going to set for the Rule 17?
Rule 17 we're doing as soon as possible. We'll do before that date.
Understood.
So we're going to need to file this.
Yeah.
So maybe we can have it filed another 25th.
All right, so Mr. McDermott.
May I approach Mr. Brennan for a minute?
Sure. Jim, can you pull up Jimmy? How was it's December 10th. I think we moved both our trials yesterday.
Would the 13th of December be available for a Daubert hearing? It's a Friday.
Possibly. I think we just put something else on this morning that would be time consuming.
I could also do the 12th if Mr. Brennan's available, and my co-counsel.
I was looking at the 10th, but Jim, could you look at the 13th and 10th?
Yeah, this is the 10th.
The 10th work for both of you? The government's available on the 10th.
So I have a. You cannot do the 10th. Okay.
Your Honor, just to be completely candid, I have nothing on the 10th. I've got to fly out on the 11th, and I've got an all-day hearing on the 11th. So I'm sorry, I'm reversing that on the 9th. I didn't fly out on the 9th, and I've got an all-day hearing on the 9th back in California, so I can't fly that day. So
well, court ends at what time?
I'm sorry, Your Honor.
You can take, a lot of people take a red eye, right? Can you come out then?
I do every time.
You can't fly out on the 9th, the evening of the 9th?
There's no way I can't take a flight on the 9th.
What about the 16th? It's a Monday. Is that?
We're fully booked that Monday and Tuesday.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available. All right, and all the other motions are taken under advisement.
Great.
Okay, thank you very much.
Thank you.
Yeah, sentencing can be, scheduling can be a struggle. There's no doubt about it. So the judge did not immediately issue any rulings on that request or the other issues discussed today. However, she did schedule 2 future court proceedings. The parties are expected to return on November 26th for arguments about evidence requests and on December 12th for a hearing about whether the testimony of a dog bite expert retained by the defense is admissible in this case. All right, let's bring back in our guest, joining us, trial attorney, former public defender Gabrielle Higgins, and criminal defense attorney and former prosecutor Joe Tamburino. Joe, I'll start with you, and I'm going to go back to the request by both parties to push the trial ahead a couple of months. They make cogent arguments. I mean, both sides are sort of on the same page. And the whole thing is about the interest of justice, right? At the end of the day, a fair trial. And what do you think the judge might do there? It seemed to make sense to me. I understand she wants to get things rolling, but the arguments seem to make sense.
Yes, I agree with you, and I think the judge will grant the continuance. I don't see why she would. It's not like they're requesting a continuance to next year, like, September of 25. And notice she tipped her hand a little bit when she said, it's April 1st, you're not going to request anything further than that, which signifies to me she's going to do it. She's going to set an April 1st date.
Yeah, and Ed Yannetti basically said, look, we're not going to ask for any more continuances, and I think that assurance sort of put them over the hump there, if there was a hump to get over in the first place. I want to go now to this Daubert hearing, Gabrielle, the idea that we saw in the first trial, and I thought it was to great effect. The state brought in a dog bite expert to talk about the bites, or don't let me call them bites, the cuts that were on the arm of the victim in this case, talking about for her, and she was some sort of expert, that they look like dog bites or dog scratches or some combination of the two. The state had an issue with it. They have an issue with it now. There's going to be a hearing to determine whether she can testify. What do you think might happen there?
I think the state mentioned there were several issues with the methodology used by this expert, and I think that's what's causing the frustration or the need to potentially evaluate the efficacy of this particular expert. I think dog bites are one of those things that are open to interpretation, open to different perspectives. I think whether or not the jury believes that these were caused by a specific dog bite or something else is going to be up to them. I wasn't particularly moved the last time around, so I'm interested to see what the new approach is.
Yeah, it's interesting. I think it's basically, she said Dr. Russell again, or the defense said Dr. Russell will be testifying. Joe, what did you make of her testimony the first time around? I remember thinking, she didn't come across as that much of an expert. She had dealt with a lot of dog bites in emergency rooms and things of that nature. I thought she came across as someone who knew what she was talking about, but like Gabrielle, it didn't move the ball that much for me.
I agree. It didn't move the ball that much. And additionally, when you look at, let me just backtrack a little bit. Even with an expert, jurors can use common sense, and they can evaluate that expert's testimony with what they actually see. And quite frankly, when you look at the scratches and the cuts on the decedent, on the victim, I mean, to me, they don't look like dog bites and dog scratches. I've seen dog scratches. I do dog bite cases in our personal injury part of our firm, and they just don't appear that way to me. So I don't think that she moved the ball much in the first trial.
Yeah, I agree. The only problem I had, Gabrielle, with those injuries was I didn't know where they came from. I mean, based on the theory by the state as to how the car or the Lexus would have hit the victim in this case, I was wondering where he got the scratches to begin with. Maybe some animal came by while he was laying out there in the snow. I don't know. That was the big problem for with that bit of evidence for me.
And I think that's why the accident reconstructionist, to me, is so critical in this particular case, right? We need to know not only the chronology of how this happened, how the decedent ended up where they were, but also we need to understand positioning and where they would have needed to be for them to have those types of injuries if those injuries came by way of the car and being run over. So I think that the focus is going to be on the accident reconstructionist, less so on this dog bite.
Yeah, I agree. I think that's going to be the central part of this case. Again, so many things about where he ended up and how things happened just didn't make sense, and the state didn't have a cogent theory as far as I was concerned. Anyway, all right, Gabrielle Higgins, Joe Tamburino, thank you so much for being with me tonight.